What's going on, everyone? Welcome to Legally Speaking. I'm your host, Blake Martinez, and today we're headed on a crash course through America's criminal justice system. We'll delve into a bit of its history, what it looks like today, and put a spotlight on a few areas and how they relate to the bigger picture. So grab a seat and let's get after it. So, in order to see how things work in today's world, let's put it up against what it looked like way back when. Hammurabi's Code is generally seen as the first structured and organized set of laws in human history. It contains 280 laws and punishments that reveal how strict and patriarchal life was back over 3,700 years ago. It was an attempt. A lot of those laws were incredibly brutal, and some of them invoked what's called a trial by ordeal, where the gods protected you if you were innocent and brought down the hammer of justice if you were guilty. And why stop something when it's only getting good? Fast forward up to the 1700s, and we see religion, namely Christianity, become a baseline for all laws and punishments. People who violated laws were seen as offenders against God himself, and the phrase, "the devil made me do it," went from being a simple phrase to the catch-all for why people committed crime, especially those who weren't kings, clergy, or noblemen. But things started to shift to some things recognizable when the Age of Enlightenment came around. Cesare Beccaria developed some of the first classical criminology principles, which we consider the foundation of how we study crime. In his essay on crimes and punishments, Beccaria had the theory that humans make decisions based on reason because we seek pleasure and we want to avoid pain. Certain members of society will resort to committing crimes when they think that the benefits outweigh the repercussions. He believed that punishment's goal was to deter us from even committing crime in the first place. He advocated that consequences should be delivered quickly, precisely, and proportionate. Not excessive, not cruel, just enough to make someone think twice. He also saw that social contract theory, another idea from the Enlightenment, had its place in criminal justice as well. Giving up a bit of personal freedom through laws in exchange for the government's protection was a reasonable trade to keep things in order and stable. Jeremy Bentham took Beccaria's ideas and expanded them even more. His idea of hedonistic calculus details how people rationally weigh the pros against the cons of their choices. Utilitarianism served as the basis of his theory since he believed laws should work to maximize happiness for the largest number of people. And he also advocated for equal treatment within the system, together with organized procedures and logical decision-making. All of these ideals come together to create the rule of law, which we still use today, and hopefully into the future. According to this principle, no one, including police officers and politicians, stand above the law. Legal systems need to establish laws that are rational, easy to understand, and promote long-term stability. It also calls for judicial independence and to provide equal justice for everyone. And now, of course, looking back, these theories were limited in how they operated. Sure, maximizing pleasure and avoiding pain is ideal, but that leaves so much out of the equation, like poverty, trauma, addiction, and mental illness, just to name a few. As we now know, crime in general has a lot more variables to consider and requires deeper understanding than just a simple cost-benefit analysis. As we move into the late 1800s, we begin to see crime as not just something to punish, but as an area of life worthy of study. So up until now, we've been focused on criminal justice, which is a system of laws, policies, and groups that enforce them. When we look at the molecular structure of crime, we call that criminology, which is the how and why crime is committed and analyzing it as human behavior. Considered by many to be the father of criminology, Cesare Lombroso challenged the likes of Beccaria and Bentham, arguing that criminals weren't just making bad choices, they were biologically different, which he referred to as the criminal man. Influenced by Darwin's theories of evolution, Lombroso's positivist school believed that criminals were genetic throwbacks, more primitive and less developed. He claimed that you could point out the members of this so-called dangerous class just by physical traits like a large jaw or long arms. While we know that Lombroso's work was flawed and pretty discriminatory, he helped move criminology towards scientific analysis and testing, and that part of his legacy still matters today. So from ancient codes and Enlightenment thinking to the rise of studying crime as a science, We've seen how ideas about justice and human behavior evolved from draconian to humanistic and rational. But as these ideas took shape, a question begged what happens next. Who's going to enforce the law? Compared to today's standards, early policing had no training, no oversight, and plenty of corruption. Officers were appointed by friends, could arrest without warrants, and were known to take bribes. Groups like the Boer, the Frank Pledge, and parish constables were all forms of voluntary, community-based enforcement, which were frequently informal, unpaid, and often unreliable to the public. These early efforts gradually gave way to more structured roles like shire reeves in the countryside and watchmen in towns. The turning point came in 1829 with the Metropolitan Police Act written by Sir Robert Peel, who's often called the father of modern policing. He set up the first organized police force in London with a military-style structure. And like other first-round tries we talked about earlier, it also had its problems, especially with corruption early on. But it laid the groundwork for professional policing. Peel also laid out a set of principles that deeply shaped modern law enforcement. He emphasized that police should focus on preventing crime, act impartially, and work with the approval and cooperation of the public. One of his most famous ideas was that the police are the public and the public are police. In other words, policing only works if the community trusts and supports it, a principle we still kind of struggle with today. Today, police officers play a huge role in shaping how our criminal justice system operates. They're often seen as the gatekeepers of the system. Compared to Peel's work in England, America-style policing has adopted some facets, but departments across the country have significantly moved toward a system of wide-reaching discretion in the communities that they serve. When used wisely, that flexibility can build trust and fairness, but when it's used negatively, the results can be severely damaging, especially for communities already facing social and economic inequality. If we look at how law enforcement agencies come, they vary in shape and size, but all focus on the common goal of public safety. Some organizations are hyper-local. University police, for example, are tasked with keeping campuses safe and considered standalone departments. When they're smaller, they're still staffed by official law enforcement, trained, armed, and responsible for responding to emergencies in their specific environment. In between are agencies like sheriff offices, highway patrol, and city police departments operating at the state and local level, each one shaped by the needs of the community it serves. For example, the needs of Idaho Springs Department may greatly differ from Denver's based on available resources and the level of crime that's going on. And at the other end of the spectrum, there are the heavy hitters like the New York Police Department, the largest force in the country, with over 36,000 officers and 19,000 civilian staff. These departments operate like almost a small town within a city, with divisions for forensics, investigations, public outreach, and so much more. So whether it's one officer patrolling a quiet campus or thousands managing a city of millions, each agency works towards the same goal when looking from a bird's eye view. Within departments, the chain of command can look different too, but patrol officers are often considered the backbone of the force. They're the ones out in the community, preventing crime, responding to calls, and handling a wide range of non-emergency duties. In fact, about 80% of their time is spent on things other than what we traditionally think of as law enforcement. Things like directing traffic, writing reports, helping at large events, or giving first aid at an accident scene. While they take on a large number of responsibilities, sworn-in officers rely on the expertise of their non-sworn-in counterparts to deliver a comprehensive response. These roles include dispatchers, crime analysts, victim advocates, and forensic experts, just to name a few. This civilian staff is critical to coordinating complex systems and ensuring institutions like fire and medical work together with police. Dispatchers are often seen as one of the most important departments in law enforcement. They answer within seconds, verify your address, collect your name and number, and quickly relay the situation to public agencies who best fit the scenario to act quickly. While doing all of this, they also assess the safety of the scene, flag any risks like weapons or drugs, and coordinate with police, fire, or medical teams usually with police prioritized if there's a broad or imminent threat. This area of law enforcement utilizes procedures called reactive policing, waiting for a call to come in and then responding. But more departments now emphasize and embrace proactive policing, where officers initiate activity on their own, like patrolling high crime areas or using unmarked cars and radar to monitor speeding. When officers engage with an individual, they can't just act on a hunch. There are legal standards they have to follow. The first is reasonable suspicion, which allows an officer to briefly stop and question someone if they observe specific, articulable facts suggesting the person may be involved in criminal activity. It's not a guess. It has to be based on behavior or context that would concern any trained officer. If that suspicion deepens and there's enough evidence to reasonably believe a crime has been committed, that becomes probable cause, the bare minimum need to make an arrest, conduct a search, or to get a warrant. Probable cause is more than suspicion, but less than proof. It's what keeps policing grounded in the details of the law rather than what they personally think. And no law enforcement role relies more heavily on these standards than homicide detectives. Homicide detectives are responsible for investigating the most serious offenses, cases where lives have been taken and answers quickly matter. Their work is about uncovering what happened, why it happened, and who was responsible. The first detective unit in the U.S. was established by the Boston Police Department in 1846, marking the start of organized criminal investigation as a dedicated role. It's one that consistently depends on sharp thinking, emotional resilience, and a commitment to upholding due process. Working closely with forensic teams, legal experts, counterpart agencies, and victims' families, homicide detectives help ensure that justice is pursued with both detail and care. Today, these detectives use a mix of formal procedure and intuition. Beyond collecting evidence and conducting interviews, they often rely on intuitive decision-making, making informed judgments in uncertain situations. This involves rapid cognition, the ability to quickly process complex details, and tacit information processing, which means drawing on experience to spot patterns or behaviors that aren't immediately obvious. All of these characteristics have to act together when a new investigation is launched, because while these traits are essential to the investigation, they're constantly working against time. Within the first 72 hours, if detectives aren't able to gather concrete evidence and information that leads to a suspect's apprehension, the case has a higher chance of stopping dead in its tracks. While the overall homicide rate declined in the 1990s, the number of cases actually being cleared or solved also dropped. In fact, clearance fell more by 15% compared to the 1970s, meaning more homicides were going unsolved despite fewer being committed. These unsolved cases, often referred to as cold cases, leave families without closure and communities without answers. But some departments began to push back against that trend, including the Boston Police Department, which had once ranked among the lowest clearance rates in the country. By adopting a problem-oriented policing model, they didn't just respond to crimes as they happened, they began identifying and fixing the deeper issues in their investigative process. And the result? Boston PD saw an 18% increase in their clearance rate. That improvement came from changes in better supervision and control over evidence collection, the integration of advanced forensic testing, and a focus on collaboration between specialized internal teams and partnerships with external agencies. Across the country, similar gains were made by departments that shared knowledge and emphasized community-driven policing, meaning that they built trust with residents, worked with them to solve crimes, and focused on preventing violence before it happened. And all of this underscores how proactive policing, when done thoughtfully, doesn't just respond to crime. It helps solve more cases, prevent future crime, and build stronger communities. Cold cases remind us what's at stake and what's possible when policing adapts to meet the challenge. Let's say someone's been arrested based on an officer's reasonable suspicion leading up to probable cause. Their case moves into the next phase of the criminal justice system, which is the courts. But courts aren't one size fits all. They're pretty complex, made up of different levels, jurisdictions, and rules that vary depending on the type of court and where it's located. At the highest level, the U.S. Constitution gives judicial power to one Supreme Court and allows for the creation of lower courts, including federal, state, appellate, trial, and municipal courts. The U.S. follows a dual court system, which means that there are separate federal and state systems. And higher courts also hold power over lower ones through a process called judicial review, which acts as the check and balance on the system. Most criminal trials in the U.S. follow an adversarial model, where both sides, prosecution and defense, argue their side of a case in front of an impartial judge or jury. The goal is to uncover the truth while protecting the rights of the accused. The prosecutor represents the government, and by extension, the public. Contrary to popular belief, they don't represent the victim. The main goal of their job is to pursue justice and not just convictions. As the key holders of the criminal justice system, prosecutors have a lot of power. They decide whether to file charges, offer plea deals, or even retry cases if there's a hung jury or a mistrial. They also carry the burden of proof, meaning that they must prove the defendant's guilt beyond a reasonable doubt. On the other side is the defense attorney, who represents the accused. Their role is to protect the defendant's constitutional rights, challenge the prosecution's case, and ensure a fair trial. Not everyone accused of a crime is guilty, and it's the defense's job to make sure that the system doesn't forget that. Once charges are filed, pretrial proceedings can begin, starting with the defendant's first appearance. This is where they officially get informed of their rights and the charges against them. A judge also determines whether the person will stay in custody or be released on bail, which allows someone to remain free while their case moves forward. In states like Colorado, this has to happen within 48 hours of arrest. At a later date, the defendant is arraigned and is allowed to enter a plea. If they plead guilty, the judge will pause to make sure that the defendant fully understands what they're doing. They're going to ask questions to confirm that the plea is being made voluntarily, knowingly, and intelligently, and that the person understands that they're giving up key rights, including the right to a trial and the presumption of innocence. So why plead guilty so early? Sometimes the sentence is a lot harsher if you're found guilty through trial, or you know that you have slim chances of being acquitted. But it's a major decision nonetheless, and courts take it very seriously. If the plea is not guilty, the case goes to trial, which unfolds in several stages. First up is opening statements, where each side outlines what they expect the evidence to show. These are roadmaps for the jury, but not actual evidence. Second up is the presentation of evidence, including physical items, documents, and witness or expert testimony. For something to be admitted, it must be relevant, material, and competent. Evidence can also be either direct or indirect or circumstantial. There are also rules against hearsay, statements made outside of court, though there are some exceptions depending on the context. Through this also comes examination and cross-examination. Both sides question witnesses and can challenge or reaffirm testimony through direct and redirect questions. And then finally, there are closing arguments, where attorneys summarize their cases and explain how the evidence supports their side. Unlike opening statements, lawyers can now argue how the jury should interpret the evidence. From here, the judge explains the law the jury must apply when deciding to convict or acquit. They're reminded that the defendant is innocent until proven guilty and that the burden of proof lies with the prosecution. Behind closed doors, the jury discusses the arguments and evidence presented, with the process lasting anywhere from minutes to weeks, eventually returning with a verdict. If the defendant is found not guilty, they're acquitted and cannot be tried again for the same crime even if new evidence comes up later. But if they're found guilty, the next step is sentencing. This can happen immediately or at a later hearing. Sentencing is where the legal system applies a punishment to someone who's been lawfully convicted. And there's several key principles of how sentences should be handed down. Proportionality, punishment should match the seriousness of the crime. Equity, similar crimes should receive similar sentences. And social debt, prior criminal history can affect this outcome. Sentencing can take a few different forms. Indeterminate sentencing allows a range like 5 to 15 years, giving judges and parole boards flexibility, but this has led to a lot of racial disparity and inconsistent outcomes. Determinate sentencing, including mandatory minimums, removes a lot of that discretion. For example, under the 1994 Crime Act, many offenders have to serve at least 85% of their sentence, resulting in longer sentences and prison overcrowding as a consequence. Part of determinate sentencing includes 3 strikes laws, which impose harsh penalties, often 25 years to life, for those convicted of 3 serious offenses. And finally, there are sentencing guidelines like those introduced in the 1984 Federal Sentencing Guidelines Act, which standardized punishments and eliminated federal parole, replacing it with supervised release. This time we spent together only scratches the surface of how we look at criminal justice and criminology. So I encourage all of you to dive deeper into a world we all should be aware of and hopefully become more in tune with. Thanks so much for joining, and we'll see you again soon.